Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about Ian Runkle. Cases that should have gone to the Supreme Court of Canada, but didn't. You might know him on YouTube as Runkle of the Bailey, but he tried to take a case to the Supreme Court of Canada and didn't. Essentially, Mr. Runkle's case was about firearms regulations in Canada. When changes were made to the firearms laws in Canada, certain guns that were permissible as restricted firearms became prohibited firearms. And the Chief Firearms Officer notified individuals who were in possession of those firearms and had registered them that they no longer were entitled to have them, and gave them steps on how to relinquish them to the government. In the circumstances, the firearms owners, led by Mr. Runkle, challenged the decision, essentially arguing that it constituted a revocation of their firearms permits as opposed to a decision to change the status of a type of firearm. They applied for review of that in provincial court, which can only consider revocations but not changes in status, which would have to be dealt with in a judicial review type situation. Unfortunately, they were denied the opportunity to have their case heard in provincial court because it was outside the provincial court's jurisdiction. They sought to appeal and were unsuccessful on appeal, and ultimately sought leave to the Supreme Court of Canada, where they were unsuccessful. And this case does raise very important issues, not about firearms themselves, but about what happens when governments use regulatory power to backdoor things that would otherwise be reviewable in an efficient and effective manner. Ultimately, the effect of the ministerial order changing the classification of the firearms did have the impact of constituting a revocation, even though it didn't, on its face, say it was a revocation. And so, if it has the impact of a revocation, if it looks like a duck and it walks like a duck, is it not a duck? This is essentially the argument, and the Supreme Court of Canada ought to have considered this case. This is not just something that applies to firearms, but to any time government uses regulatory powers to do things that might interfere on somebody's rights in the criminal or other context. It would be a good way for the Supreme Court of Canada to rein in the way that government takes its regulatory powers and uses them to oust the reviewability of certain decisions that would otherwise be reviewable by court, and consolidates more power with government in a way that makes it much more difficult for ordinary individuals to challenge that use of power. Unfortunately, the Supreme Court of Canada, I think, failed to see the issue about the broader power considerations and not just the issue about the classification of firearms in this case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, and share with your friends.